Convention of the Rights of the Child. Many times it is not well implemented. And one of the most problems that we faced in courts, not only in Portugal, it's the huge delay of the cases. And sometimes the cases ends because the court cannot do anything else because it took too long and several years has passed without contact with disattachment, and the courts end the case because they feel they don't have the means to do anything, or because the child is now with 18 years old, so the court cannot have more intervention. It is considered by the Court of Human Rights under the Article 8 of the Convention that no accomplishment of the positive measures by the states in order to provide effective decisions timely manner. So the cases were too excessive in time, and it established de facto situations. The Court of Human Rights have several convictions against Portugal, for example, and this is a transversal situation because cases are not ruled in a diligent way, not even timely manner. What should rule the people's and families' lives would be the court's decision and not time. European Court of Human Rights and also the Council of Europe with this new recommendation from May 2025 is calling attention to the states members under the Child Convention of Children's Rights that courts must have special diligence in these children's cases, even more when the children are in cases of separated parents or in high conflict situations between the parents. This is related, this duty of timely manner, not only with Article 8 of European Convention of Human Rights, but also with the European Charter of Fundamental Rights and the Convention of the Children's Rights. In order to solve the cases in a timely manner, because time cannot be the factor of changing in families' lives or in children's lives. And this is a duty for the states. The duty to good administration of justice is a fair, it's efficient, it's effective and timely manner. Too long in time, the relations are lost, especially when there are huge conflicts. The court starts saying that they have no means to deal with the situation. But the problem is not about the means, because we have the means, but we wasn't diligent. We didn't act in time, in proper time. European Court of Human Rights is stating in its convictions that the courts are responsible for the execution of their decision. So we have here two times. One, since the case is filled in the court, and the courts have the duty of good administration, and then the time the court take a decision, the courts are responsible to execute their own decisions. This good administration has a duty for states, but also the correspective right for citizens. Every citizen has the right to claim for a good administration of justice. I cannot say that this is a duty for the government. The government may have to take action. The government has to make new laws. No, we have the laws and we have to apply them in a case by cases, by courts. So we all are responsible for this. We cannot just blame the system, because we are the system. The lawyers, the judges, the courts, the government, the technical assistants to the courts, everyone that are not specialized in children's matters, in children's hearings, in dealing with high conflict cases, and identify correctly if it is a situation of parental alienation, of domestic violence, and if it's a domestic violence or a situation of abuse, which is the limits that the law imposes in those situations. If I can speak about parental alienation at the same time of domestic violence in the same case or not, or if they exclude between them, because if we have a parental alienation situation, the rule to apply is different of a situation of domestic violence. In domestic violence, protect the child, it's to keep her away from the aggressor. In parental alienation, is to reestablish the bonds. And sometimes in domestic violence situations, the court misconfuse the concepts and establish shared residence or visitation without supervision of the child with the aggressor. But the law expressly says that a child witness is a child, a victim, and must be protected, because that parent, the aggressor parent, doesn't fulfill the competences that he must have to ensure and to guarantee the safety, emotional, not only physical, but emotional, of the child. So all these are complements of the duty to good administration of justice, because we need to be diligent. What this means, it's not only to work fast, to be efficient, and to take decisions in timely manner. It's to take the decisions that work for that case. It's to have specialized training to correctly identify the situations and apply the role according to this, to execute their own decisions. Otherwise, people will feel that they will accomplish if they want to, because no one will oblige them. The children won't want to go to the father, I cannot oblige them. But it's the duty of the court to see why this child is refusing the contact. These have an objective and serious justification or not. And if not, take all the means to establish that relationship. Me, as a citizen, I have the right to claim for a good administration of justice, because otherwise justice is not being served and my rights are eventually being violated, or the children's rights are being violated, because if the court is not able to ensure protection in each case in an efficient manner and in a timely manner, we can cause more damage than good. So this is the relation between the interplay between the execution of court decisions and the good administration of justice. Decisions that are adequated to the specific situation, to the specific case, in each time, in each moment, and not after. When this is not accomplished by the courts, many times we have convictions by the European Court of Human Rights because we failed. We failed as a system that should protect children, that should protect the victims, that should protect the family and children's bonds in high conflict between the parents, not misconfuse concepts. And this rigor, it's not about being tough, it's about having a deep knowledge of the law, to have multidisciplinary training, not only for the lawyers and judges, but also for the psychologists, for the social workers that intervene assisting to the court. Many times we see reports about domestic violence promoting shared residence because they misconfuse the concepts with parental alienation. They don't know the literature. Sometimes we see this in forensic expertises, and they are psychologists, and they should know the literature based on psychologists. Where we have a real situation of domestic violence, of neglect, of abuse, we cannot use parental alienation. Why the judges don't have a critical look, a critical analysis of these reports? They don't have specialized training on these matters, so they just leave it, they don't question. It will create a bias on the analysis of the case and can lead to a non-protective system for the family and for the child. Situations that the court says that we don't have means to restore family life. Well, but the means we have in our law. And if a parent do not cooperate, also European Court of Human Rights states that is the obligation of the state to improve all means, and if don't have means, create legal rules, new rules. European Court of Human Rights don't like too much of the forced or the coercive execution, ordering the police to take the child, but states that if the problem are the parents that undermine the execution of the court decision has the duty to apply fines. And several times the court doesn't even make an advertisement to these parents. So they feel empowered and they feel they can do whatever they want to. And then the court says, we don't have the means. Yes, we have, but we don't use them, or we don't know how to use them. And then the relations are broken. And sometimes we cannot reestablish them. If I see that this right is being violated in a case I have in court, I have the duty to invoke the legal instruments to bring to my requirements to the court the articles of European Convention of Human Rights, the articles of Children's Conventions of Human Rights, the articles of Istanbul Convention or Lanzarote Convention, the reports of Grevio and Committee of the Parties about implementation of Istanbul Convention, for example, the child-friendly justice recommendations, the articles of the European Charter of Fundamental Rights, and claim to the court to apply those rules because it's a duty of the court. I need to think since the beginning that I am preparing something that in the future, if this doesn't work, I need to use to go to European Court of Human Rights. And European Court will analyze the case and how I made my argumentation, how I did plead for the respect of human rights, of fundamental rights. All courts, even domestic courts, are obliged to implement and apply these rules. And why? Because we are members of European Union. We are under the rules of European Union because we sign a Children's Convention. The Charter was implemented by the Lisbon Treaty in 2007, so it's a treaty that expressly says that from now on the Charter of Fundamental Rights will have legal force. Also, the European Convention of Human Rights and recognize the European Court of Human Rights by a treaty. So we signed that treaty. We are under that rules. So we must comply, we must apply them. If we don't, then we must respond to the international courts or the European courts for that violations.